They say that a rose by any other name would smell as sweet. If, however, you name the wrong defendant in a lawsuit and the statute of limitations runs before you learn your mistake, that can smell like trouble. In Zielinski v. Philadelphia Piers, the plaintiff asked the federal district court for help with just such a problem. In February 1953, dock worker Frank Zielinski was injured at work on Pier 96 in Philadelphia. The injury occurred when he was struck by a forklift being operated by Sandy Johnson. Zielinski filed suit in district court against Philadelphia Piers. Zielinski alleged in his complaint that Philadelphia Piers owned the forklift and that, at the time of the collision, Johnson was a Philadelphia Piers employee acting within the course and scope of his employment. Philadelphia Piers answered that allegation with a general denial. During discovery, both ownership of the forklift and Johnson's employment were addressed. First, in an interrogatory answer, Philadelphia Piers stated that it had turned the matter over to its insurance company for investigation. Second, during Johnson's deposition, which was also attended by the attorney for Philadelphia Piers, Johnson testified that at the time of the collision, he was a Philadelphia Piers employee. Then, at a pretrial conference over 2 years after the suit was filed, Zielinski learned that a year before his injury, carload contractors had purchased Philadelphia Piers' freight-moving business. Thus, Johnson had become a carload contractor's employee without his knowledge. By the time Zielinski learned this information, the statute of limitations had expired, and Zielinski was barred from amending his complaint to name carload contractors as the correct defendant. Zielinski filed a pretrial motion asking the court to find that Philadelphia Piers had admitted that Johnson was its employee.